What you're about to watch is a segment edited from one of our 4-hour board certification courses. Each segment focuses on an area of governance that board members frequently ask us to explain in more detail. We produce these clips to provide information on demand, giving you the option to revisit key topics whenever you need clarity, reinforcement, or a quick refresher. The video is a discussion for Condominium Association board members that covers the Florida statutes governing the records request requirements. This is a copyrighted video by Ardor.
If they want access to the records, they must submit a request in writing. There is no requirement for it to be certified or anything else. It can be an email, regular mail. They can drop a note by the office or the management company. It can be made by the unit owner or their authorized representative. And it may include a general request. I want to see all of the records, or it may include a specific request for a specific record that they want to see. The association has to respond within 10 working days with the records. If not, the association is automatically in violation of the statute and subject to a $50 a day fine up to $500, and that is only if the person whom requested the documents pursues a legal remedy for the fact they did not get those documents. It's not assessed by the DBPR. Those document inspections must take place within 45 miles of the property or in the same county, or they can also alternatively be supplied by email, online portal, or a secured shared folder like a Google Drive or Dropbox. Renters have some limited right to view documents. They can inspect and copy the declaration of condominium, bylaws and rules, and any structural integrity inspections are subject to renter review. Recent statute changes require that you provide a checklist with those documents that you provide the owner or their representative. That checklist must indicate all of the records you're making available related to that request and list any of the records you're not providing that were requested in the request by the owner or their representative. That checklist becomes an official record, and it must be maintained for 7 years by the association. According to the statute, this checklist creates a rebuttable presumption that the association complied with the records request law. So this is protecting the association. So you want to be sure that this checklist is provided anytime there is a records request. Now, it mentions that if there are official records might not be provided as part of the request or response that were asked for. What do we do then? Well, 718, 111, 12B indicates it's the responsibility of the association to make a good faith effort to recreate or recover any missing records. They can go back to prior board members, other former management company, vendors, banks, whatever resources might be available to find those records or recreate those records. The checklist in response to the owner's request must identify in detail which records aren't available, and then you want to keep track of that good faith effort to find those records or duplicate those records, and then preserve that along with the owner's request as well. As any documents are made available subsequently, because they are recovered or recreated, the date they were made available should also be included. So you're going to create, an initial checklist. It's got things missing. You're going to create a document that says, here's what we did to try to recreate or recover. And then a document that says we weren't able to get any, or we were. The subsequent records were provided at this particular date. Some things that aren't available for owner inspection include attorney-client privilege communication. So anything that you've discussed with the attorney in private, that's privileged communication is not accessible as part of a records request. Personal owner information, there may be details like bank accounts or social security numbers that you obtained because you screen new owners or renters. And while it's a good idea to redact those things or destroy those things, they may be in your possession. They are not available to owners on a records request. Personnel records, not available, except for the extent of their salary and compensation. If they have an employment contract, that's also available for inspection. But if you have disciplined an employee or discussed, have personnel records of any sort, those are not available to owners on a records request. Any medical records of homeowners or residents? There may be times when you're dealing with an ADA situation or an accommodation for someone who has a disability, and you've obtained some level of documentation. Well, that's not available either. That is not deliverable as part of the owner records request. And certainly things that make sense, like security system details or software information, those things aren't part of discoverable. They're a part of discoverable